This is the Financially Simple Podcast, a show dedicated to destroying the complexities of money for today's small business owner. And now, here's your host, pizza-loving, certified financial planner, Justin Goodbread.
Hey guys, welcome to Financially Simple. I'm your host, Justin Goodbread, and today I have a special guest with us on the podcast, Robbie Robertson. We're dealing with the subject of building a best-in-class risk management department with the idea of growing the value of your company. And we've reached a particular topic which I don't know very much about. So I had to reach out to the expert, and I happen to know an expert in this particular topic. Today's episode is titled Intellectual Property, what we commonly refer to as IP. So on the podcast today is my personal attorney, Robbie Robertson, and I've hired Robbie to do some IP work for my company, Financially Simple. So I'm in full disclosure, folks, I am working with Robbie. Now, doesn't mean that you have to. It doesn't mean that Robbie's going to tell you anything about what we're doing. But I can tell you he's doing some IP work for me and our company. But with that, hey, Robbie, welcome to the show today, man. I'm glad to have you with us.
Glad to be here.
Robbie, tell me, and maybe more importantly, tell the folks, who is Robbie Robertson?
Well, I grew up in Dalton, Georgia, in the heart of the carpet industry. And my first job in high school was working summers in a carpet sampling mill where I learned what is meant by a hard day's work. Ultimately, I obtained my Bachelor of Science degree in Chemical Engineering from Auburn University in 2000, where I also minored in music. And after undergrad, I worked for a few years, including work with Nalco Chemical Company. And after that, I decided to go back to law school and graduated from the University of Tennessee College of Law with my law degree in 2005. And worked in Knoxville, Tennessee for a boutique IP law firm after graduation. And 8 years after that, I went out on my own to open Robinson IP Law in 2013. And our primary areas of practice are, patent and trademark, and we do some copyright work as well. We have clients from all over the country and even some from other countries, and such clients can range from size from the multi-billion-dollar size to individual business owners or inventors down the street. Although my background is in chemical engineering, I do a lot of patent work in the mechanical and electrical arts as well, and I have a partner. His name is Matt Gooch. He's also from Knoxville, Tennessee as well. And on the personal side, I have a wife of 19 years and two middle schoolers, so I'm enjoying that.
Yeah, that's a busy life, isn't it?
And we live here in Knoxville.
So, Robbie, I got to ask you two questions. Number one, you said minor in music. What was that about, brother?
Well, my primary instrument is voice. I've been in performance groups all my life, music performance groups, and that helps a little bit. I've dealt with some litigation, believe it or not, with copyright, dealing with music, and so that background has helped me in that area. But that's just part of what I did back in the college days.
So the second question I have for you is, when it comes game day in Tennessee, who are you cheering for? You cheering for Big Orange or the Bulldogs?
Yeah, I grew up in Georgia, but my parents both went to Tennessee, so but more of an orange color usually. So,
Robbie, I had a little bit more higher expectations for you than that. I really did. I really did.
No, I have respect for all the SEC. Georgia's a good team.
So I went online and I pulled up Robinson Law. And so you have a website. We're going to talk about that a little bit. I was seeing your partner there, a little bit about your bio on LinkedIn. But let's dive right into the question. And again, pretend like you're talking to Justin. I can be a little thick-headed sometimes. Robbie, what in the world is IP or intellectual property?
Well, intellectual property traditionally is broken down into four categories: patents, copyrights, trademarks, and trade secrets. Now, that's not everything, but those are the four main categories.
Can you explain each of those individually? So you gave me four there. Just give me a quick summary on what each one of those are.
So like a patent is if you have an invention, like a method for doing something, or an apparatus or a composition or something like that, a composition of matter, that is, you could get a patent on it. And if you're seeking patent help, know that you will need to work with a registered patent attorney or patent agent. There's a separate bar exam that patent attorneys have to take to be licensed to practice patent law before the U.S. Patent and Trademark Office. And in order to sit for that bar exam, you have to have an engineering or heavy science degree. So that puts us in a smaller category of attorneys that are out there. So only a small percentage of attorneys can even do it. But a patent is covering an invention. Copyrights cover expression of information, not the information itself, but just expressing information. If you're drawing a painting, if you're writing a musical composition, or if you're writing a novel, all of those things are copyrightable material that you can register with the U.S. Copyright Office. The third category, trademarks. Trademarks are just protecting brands. And really, the main people that are being protected by trademark law are the consumer, because we want to make sure that there's no consumer confusion between two goods or services. You don't want to have two companies out there that are selling Coca-Cola for soft drinks. There can only be one, right? So that's what trademark is for. And then trade secret's probably the simplest of the four. The idea of a trade secret is just to keep things secret. If you take certain steps, keeping things secret under lock and key, literally and figuratively, then if someone steals it, then you have recourse to deal with that. And probably, speaking of Coca-Cola, one of the most famous trade secrets that's out there is the Formula 4 Coca-Cola.
Okay, so let's play a slight game here just for my simple mind. Let's name a couple of items or a couple of things that I'm aware of, and you tell me where they fit, if they're a patent, if it's a copyright, a trademark, or a trade secret. Is that okay to do this?
Sure. Yeah.
Okay, so Bush's Beans here in East Tennessee has a dog that goes on TV and pretends it can talk. Can you protect that marketing style?
That sounds like it's something that would fall under both copyright and trademark law. I think that you would probably see that in the context of an ad or ads. Mm-hmm. And so there's that protection from the trademark side, and there's copyright protection, and you're obviously expressing information through a character who is visually drawn up or whatever, whether it's computer generated or somebody actually drew it out or whatever, that's protected under copyright. So that would fall under both copyright and trademark law, I would think.
Okay. So I ran across a client the other day who brews microbrew beer. Okay. And he wants to take and eventually one day sell his company. Which of those four type would it be patent, copyright, trademark, or trade secret for the microbrew? I'm assuming it's probably multiple, but if you got a beer distillery that wants to bottle and have their own brands and everything, and I'm assuming the flavor, which one of those four does it fit into?
The primary one that jumps out in that example is trademark law, because you're going to want to protect your main brand, the core brand, as well as you probably have specific product names, for your different beers. There are so many names out there for beers.
Right.
I mean, there's a ton, but it would probably primarily be trademark. But you could also have copyright, because if you have a logo that has artistic components to it, then there would be a copyright in the logo. And also, if you have a secret brew, that you put together and nobody can reverse engineer it, then that could be a trade secret.
Interesting. So I ran across another individual, and they're an engineering firm, and they're more of a development engineer. I would call them research and development, and they're actually making widgets. Let's just call it a widget of some sort. Let's pull it outside of my client. I'm thinking here in Knoxville, we have the Sun Sphere, this big, gorgeous orange ball when it's clean during the summertime that shines all around. It's almost like a gold ball. Will that fall into patent law, or does it go into trademark and copyright and trade secrets as well?
That was before my time, but I do think there was some work done on that. I think it was under patent law, and I think it may have been under trademark law as well.
Okay.
But like I said, it's been a while. I think if there were patents on it, which I'm not 100% sure, but I think there might have been, those would have expired by now.
Okay, so these are the type of questions that I field every day. They say, hey, Justin, I've got this idea. I've got this software program that I just created. I have this invention. I'm going to use that term very broadly. Or I have this secret recipe. And each particular case may not necessarily fit into one of those four categories. They may go into multiple. Am I hearing that right?
No, that's exactly right. Every situation is different, and it's fairly common, quite frankly, for you to have something like if someone brings something to me that it falls in more than one category, and we have to look at, well, what's the most important category, and what are we going to focus on, or are we going to focus on more than one category? Is it worth spending the money to try to go with multiple avenues? And sometimes it is, and sometimes it may not be, but we just discussed that.
So let's continue down that thinking then. Let's say that Fred Flintstone has something, whether it be a widget or an idea, a computer program, a brew, whatever it may be. At what point does that individual, that owner, that inventor, that whatever company it's going to be, when do they actually need to reach out to start thinking about hiring an intellectual property attorney?
especially if you're dealing with patents. With all categories, the sooner the better, early and often, but especially when it comes to patents, you want to go see a patent attorney as soon as possible. You do not want to delay, and you certainly do not want to disclose your idea to anybody other than your patent attorney until you've got perhaps a non-disclosure in place or something like that, because you can lose rights instantaneously for certain things, especially rights for patents in foreign countries, because most foreign countries do require absolute novelty, which means that you actually have to file a patent application before you disclose your concept to anybody outside. So the short answer is do it early and often.
Now, before you and I met years ago, I knew I needed to protect something that we're working on, and I'll say it's one of the things we're working on is the book. I knew I needed to protect it, but I didn't know how, so I did a Google search, like many people do, right? I mean, we're all armchair quarterbacks to some degree, and I did a Google search, and I found a company online, let's just call it a web-based company, and I sought to hire them. And my experience was interesting, to say the least. How is working with a local company or an attorney that owns their own practice, similar to what you do, how is that different? Or what would the experience be like differently for me to hire you, or for any person to hire you or a firm like yours, as opposed to working with an online organization? Is that a fair question for me to ask?
It is, and there's a multi-pronged answer to it. And the first answer is simply this. You get what you pay for. You'll go online and you can find really cheap ways to try to get trademarks registered or copyrights registered or whatever else, but buyer beware, you will only get what you pay for. And there's a lot of companies out there. You'll probably see commercials about companies on TV that can help you with patent ideas. My recommendation is just to make sure you go to a registered patent attorney and talk to them. Now, as far as working with someone local, I can tell you this. I have multiple clients throughout the country that have never seen me face-to-face, but they know that I'm a patent attorney. I do patent and trademark work, and we've got a relationship that's developed over time. Maybe they were referred to me by another prior client that was happy with our work. So it's not necessary that you use somebody down the street. I mean, you could use somebody, if you're in California, you can call me and use me. And quite frankly, it might be cheaper because I can guarantee you that my hourly rate is going to be a lot less than somebody in, Los Angeles or San Francisco. So you don't have to be down the street, but you do want to make sure you're dealing with somebody. If you're dealing with patents, you want to make sure you're dealing with a registered patent attorney. And if you're dealing with any other IP, that you're dealing with somebody who does that on a regular basis, and that's the primary focus of their law practice.
You are listening to Financially Simple, destroying the complexities of money for today's small business owner.
So you just led into one of my last big questions I have for you is, what does it cost? What does it typically cost? And I know the answer, Robbie, is probably going to be the same answer that I would say if you would ask me a pricing point saying, Justin, it depends. But what could the range be? Let's take each of those four items. Based on what you said earlier with a patent, because we're going to have an attorney who's a specialist and have a second, maybe a particular test in order to practice before the patent office, what does a patent cost to push through or to get a patent on an item?
Yeah, that is a very difficult question to answer, and I can give you maybe a very rough idea. Now, for example, my hourly rate currently is $275 an hour when I'm doing hourly work. And when it comes to patents, that's usually billed on an hourly basis. There are a few things that we bill on a flat rate when it comes to patents. But if I'm drafting a non-provisional patent application, then I'm most always going to be billing my hourly rate. And so if you are filing a non-provisional U.S. patent application and you want to prosecute it through to get one issued patent, so we're talking about one application, trying to get one issued patent with just a normal number of claims or whatever, I think you could easily expect to spend somewhere between $10,000 and $20,000, and that'll vary depending on who you use and how much their hourly rate is. And it also depends pretty much on how much resistance you get from the patent office, how much pushback you get from them.
So when it comes to patent, am I oversimplifying this by saying it's a standardized, I wouldn't say standardized, but it's, for my simple brain, it's a process that ultimately the attorney who's going to help you in that area is going to charge an hourly rate on. So you're looking at expertise and price at that point from a price per hour standpoint.
You are, and that's just a very rough example. There are situations where it's going to cost more than that.
Right, I understand.
To get all the way through, and there are some that are going to fall below that. So.
Okay, so let's change gears to the second one. Now we're going to deal with copyright. I watched a movie years ago that dealt exactly what you're talking about. It's called A Flash of Genius, which was a gentleman was suing a major industry for stealing the intermittent wiper motor from him. And he actually used the book Moby Dick to explain, I think, what you're describing. He took the first 7 words of Moby Dick and said each one of those words independently didn't mean anything, but when you put them together, it was the first major catch of Moby Dick. Therefore, it had the chance to be protected because of the way they arranged the words. Is that kind of copyright?
It doesn't protect information itself, but it protects the expression of that information or that whatever it is. Actually, that example of what he was saying is copyright, but ironically, the movie itself is dealing with patent law.
Right.
So, but what you're saying is correct. Yeah, putting words together to express something would be protected under copyright.
So what does copyright cost? If I want to protect an expression, what does that cost? Again, I know it depends things, but how does someone even consider the pricing on that?
If I remember correctly, I think the current government fee for a single work is like $55 or something like that. And I would say you're looking between $500 to $1,000 probably for a fairly straightforward work. I mean, some works are going to be more complicated. There's going to be parts of them that are not protectable or that were part of a prior work, and you have to deal with all that. But for a pretty straightforward situation, that's a pretty good estimate.
And trademarks, so I'm a CFP, and in the CFP, it has a TM. You have to actually spell it all capital letters, Certified Financial Planner, TM. So that's a trademark. What would it cost for the average person to trademark a slogan or something?
So if you have a single mark and you're trying to protect a single type of good or service, so it would fall under one class, then if everything goes perfect after you file the application, you could possibly get it registered for about $1,000. But the caveat there is that it's one mark, one class, everything going perfectly smooth. It's very common for you to get some pushback from the trademark office, though. They may reject your application because the examiner found a similar mark, that was prior to yours, and they reject your application. So that would be something that the attorney would have to deal with before you could get a trademark registration. So it would cost more in that situation.
And then my brewmaster who has a brew, the best-selling brew that he has, if he wants to protect his mix, his trade secret, how much is someone like that looking at trying to protect a trade secret of that simple example that I'm giving?
So everything we've talked about so far deals with some type of formal application process. It doesn't have to. We can get into some examples of where common law trademarks and copyrights that are not registered. But for the most part, if you want to get the best protection possible, those 3, patents, trademarks, and copyrights, you would want to try to get formal registrations. But trade secrets are different. There is no formal process of registering anything. It's just a matter of taking certain specific steps to make sure that you keep your secret. Because if you don't, then you lose your trade secret protection. So basically in that situation, you would just be sitting down with an attorney and you would be discussing with the attorney what steps you need to take to protect whatever it is that you want to protect.
So that plays exactly where one of my last questions. As you and I were talking before we went live on the air here, we talked about that we're dealing with business owners who are trying to grow the value of their company. And I know it's not in your purview, but in my world, I'm constantly trying to increase corporate value. So at some point, the business can be disposed of, hopefully for profit, to a third-party buyer at a maximum value. Okay. In that context, let's say that now I have worked with you or worked with an IP attorney, and I have used which of those 4 that fit my particular business model. Let's make it super simple. Let's say I have a patent on a provisional patent, and now I go to sell my company. If I have a provisional patent on something, number one, can I transfer that patent ownership? I may not even be using the right terms to a new buyer. And number 2, can the new buyer then, if they didn't buy my business and they saw the patent, can they then go out and duplicate and go to China and repeat my patent or repeat the widget from like a protection standpoint? That's 2 very hard questions. So I'm going to have to break them down for you as we answer these.
Yeah, I'm going to unpack that a little bit because I think it calls for about 5 answers.
Please do.
So as far as patents are concerned, there is what's called a provisional patent application. It's an application that can be thought of roughly as kind of an informal application, and it buys you up to 1 year before you have to file the more formal non-provisional patent application. But technically speaking, there's no such thing as a provisional patent. There are only patents. And
Okay.
if you have a patent application, whether it's provisional or non-provisional, that's pending, then yes, you can assign that. If you've already made it through the process and you have an issued patent, then you absolutely can sell that as well. And just for a little bit more background, the life of a utility patent under U.S. law is 20 years from the filing date of the non-provisional patent application. So that gives you an idea of how long they last. There is an expiration date on patents.
Okay.
Yeah, I don't know if that fully answered the question.
It does. Let's say I'm in the process of selling my company and I have a patent. Let's go past the provisional standpoint. Now we've done the work and I truly have a patent on the widget or the machine, whatever it is. Let's say during the process, as I'm trying to sell the company, I have to disclose to the buyer, obviously under confidentiality agreements, et cetera, what the patent is. Can they take that item legally and go to China and have China reproduce that item and then go into competition with me? Or is there recourse if they did that I could be protected underneath the patent law?
So if you have a patent that's still in its life, and you're still within that 20 years, then that patent is already public information. You know, patents publish publicly. And
Okay.
so it's all secret information up until the application or the patent publishes. And at that point, it becomes public. And then you have that limited monopoly for up to 20 years after the filing date. So if someone takes that information and tries to build something in China, they can do that, and they can sell it in China, and they can ship it over to Thailand or wherever. But if they import it into the U.S. or sell it in the U.S., then that's an infringement under U.S. patent law. So it won't protect you from somebody running to China and selling it in China, but it will protect you from somebody running to China and selling it back into the U.S. There are ways to get protection in China, and that would require getting a patent under Chinese patent law.
Wow. So as you can probably tell from my questions, Robbie, this is an area of the world that lawyers deal with that I know very little about. So I'm going to ask you the last question I typically ask my guests. What is the one question that you wish people would ask you that maybe I didn't ask?
I thought about that, when you brought it up previously, and I think that the question I would love for people to ask is, what would you do if you were me? And I know that's a tough question to answer sometimes, but sometimes people come in with an agenda, or they already know what they want, and it's so nice for someone to say, you know what, you tell me what I should do.
Right.
Because every situation is different. What I might do in one case would be different from a different case. But
yeah, that's interesting.
Anyway.
That's interesting. So we've covered a lot for me, and I'm a little bit saturated right now. So I'm going to try to conclude this and ask you some rapid fire questions to make sure I understood this. What was your quick one sentence answer to what is IP law?
IP law is generally patents, trademarks, copyrights, and trade secrets. Those are the four primary categories.
Okay. And who is it that needs to protect their IP?
Virtually everybody. Every business has a brand and probably deals with copyright, at least at a minimum.
Okay. And then you gave me 4 different items that fall underneath IP in a quick one-sentence rapid fire. What is the definitions for patent, copyright, trademarks, and trade secrets?
Patent law protects inventions, concepts. Copyright protects the expression of information through things like images or written text and things like that. Trademark protects brand names, and it's primarily geared to protect the consumer from confusion. And then trade secret is just legal protection when you take certain steps to keep certain things in your business secret from competitors.
Okay. And so we talked about that when someone needs to hire an attorney, they need to speak with them soon and often, as soon as they know something. Did I hear that one correctly?
Yes, especially true for patent situations. But you want to talk to them sooner than later if you can.
Okay. We're not going to go through the cost again, but you understand we always get cost as what's the cost involved. So I think you did the best you could to answer those various questions in each of those 4 areas. And then I love what you said about the one question which people would ask you. I like that what would you do? I like that because you are the professional. You deal with this. You know the pitfalls. So did I miss anything? If you were talking to my 10-year-old son, did I miss any question or anything that you would try to tell them that we didn't cover about what is intellectual property?
The one thing I would say is more general, and it's the idea of proactivity versus reactivity. I would encourage everybody to be proactive, to contact their intellectual property attorney to ask, what do I have in my business that's protectable, and what steps should I take to protect it? Because if you do that and your competitors don't, you're going to have a leg up on those competitors immediately.
So, Robbie, where can people get more information about you in particular? I looked at your website. Is that where you would send them to? Do you have a phone number? Where can people get a hold of you at?
Yeah, our phone number is 865-978-6480, and our website domain name is robinsoniplaw.com. That's my name, Robinson, ROBINSON, IP, P as in Peter, law, LAW.com.
And I heard you correct to say that you currently are working with individuals nationally. Is that correct?
Yeah. In fact, we have some clients that are from overseas, too.
Oh, wow. Do they have to speak English to work with you?
It certainly helps me.
Well, brother, I appreciate you coming on the show today. I'm sorry my questions were so poor. This is not one of the areas that I'm very versed in, and so I appreciate you helping me with that. Hey, guys, thanks for listening to Financially Simple. You know, having a good attorney, I talk about it every week. In fact, next episode, you're going to hear me talk about an attorney and what they can do for you in protecting you from litigation. But having a good attorney that knows what they're talking about, I'm telling you, they're worth their weight in gold. And I know Robbie personally, and I can vouch for him and his experience. And so if you have any questions on that, reach out to him. If you thought the show was of value, just, shoot him something on LinkedIn and say, hey, Robbie, thanks for talking with Justin on Financially Simple. While you're out there, if you like the podcast, do me a favor, share it with a friend. And if you don't like the podcast, especially after my poor questions today, do me a favor. Share it anyways. Hey, look, I say it every week. Life is hard. It is. Life is good, and life can be frustrating. Trust me, I'm dealing with lawyers. No offense to present company. It can be frustrating. Money doesn't have to be. Let's continue to make our lives at least financially simple. Hey, y'all go out and make it a great day.
You have been listening to the Financially Simple podcast. The information in this show is for informational purposes only. This show is not investment advice. Instead, seek help from a competent financial advisor. Justin Goodbread, CFP, is an investment advisor representative of Heritage Investors, a registered investment advisor.